Here. Okay. Well, hello everyone, and welcome to a new session of the EALG webinar series. My name is Carlos Llorente, and I am the managing partner of M2 Legal Services, which is the Spain-based member firm of the EALG. And I'm also co-chairman of this group. For those of you who don't know, the EALG is a global alliance of law firms, which was created in 1985, and we are presently in 27 locations across the world. Our aim is to offer our local clients with the best and most efficient legal advice abroad. If anyone that is watching this webinar is interested in our activities, just simply take a look at the website, which is ealg.com. And well, in addition to what I told you about me, I am going to be today's speaker in this new webinar, and well, I hope you like it. The title of the webinar is the one that you see there, and let me just tell you three things about the title. In the first place, my only perspective here is going to be the perspective of the European Union. Okay, so I'm going to talk from the perspective of European Union law because I am a lawyer authorized to practice law in Spain, and I'm also a law professor here in Spain. Spain is a European Union member state, so therefore I am authorized to give my opinions on European Union law. Second, and related to this first thing, I'm not going to offer any opinion from the perspective of English law because I'm not an English lawyer, so I wouldn't dare to do that. Although I am, fluent and familiar with English law and other common law jurisdictions, but I do not pretend to offer any kind of advice or information on English law. The perspective here is going to be European Union law as we see now, international commercial situations where one of the parties to that situation is UK based. Okay, so that's the perspective. And finally, for the third place here, well, my presentation is going to be focused, strictly speaking, in international commercial matters, litigation, or transactions. Okay, when we talk about international litigation in any area of private law, you see that the world is huge, and specifically from the European Union law perspective, but I do not pretend to make any comments on private international law in the European Union outside of the area of international commercial litigation. So let me show you in the first place here. The beginning is a beginning where we talk about a marriage and a divorce, right? And this is what has happened with the UK and the European Union in the area of private international law. I'm giving you there some information that you probably know, but we have been together in this for 47 years. The UK joined in January the 1st, 1973, joined what we call now the European Union, and they left on January 31st, 2020. So throughout all those 47 years, well, the UK, as the rest of the European Union member states, have been governed by the same set of rules in the area of private international law. Don't forget that according to Article 81 on the Treaty on the Functioning of the European Union, the European Union is the most important legislator within the European Union in terms of what the treaty calls judicial cooperation in civil matters. In other words, in private international law. So that means that for a long, long time, the UK and the rest of us have shared and have adopted the same European Union legal instruments in private international law. It is true that the UK, as it is the case still today with Ireland and with Denmark, although for different reasons, but they have the right to opt out to certain European Union regulations, but the UK was somehow a very loyal partner in relation to this, in relation to the application of the majority of the sources of European Union law in the area of private international law, right? But unfortunately, as it happens, the European private international law instruments ceased to apply in the UK after January the 1st, 2021, okay? So that was the perspective that I wanted to offer you, because for a long while, I mean, it's 47 years, the majority of us here are older than 47 years old, right? But we've been living in a world in the area of private international law where we didn't have to question ourselves what is going to be the position of a UK-based party in relation to issues of international jurisdiction, applicable law, recognition and enforcement of foreign decisions, because we knew that they had the same rules, and this is also very important, we had the same hierarchical interpreter of European Union law, which is for us today the Court of Justice of the European Union. But that suddenly broke in January the 1st, 2021. From that moment on, well, the common European Union instruments in private international law, well, they are still applicable here, but they are not applicable anymore in the UK. And obviously, we continue doing business with UK companies. We continue to give legal advice to companies and persons from the UK, but we have had to change our mindset. And basically, this is the purpose of the seminar today, just to analyze how we deal with certain situations now that the UK is no longer a member state of the European Union, where no longer those legal instruments are in force. And well, let me show you here in the first place, what are the most relevant instruments that we have in European Union law in the area of private international law in commercial matters. So if you see there, I have identified the most important, again, legal instruments or sources in those three areas, which at the same time are the key areas in private international law. First, international jurisdiction; second, applicable law; and in the third place, the problem of the recognition and enforcement of foreign decisions. We are going to review each of those sectors next, and we're going to see exactly what is our position in relation to UK-based parties in those three areas. But I thought it was important just simply to remind you what those sources are. In the area of international jurisdiction, you will see there in the first place that the most important source in force nowadays is what we call Regulation Brussels 1 bis, and others call Regulation Brussels 1 recast. Is the same thing. There is a link to that regulation, so in case you get a hold on this presentation, you could just go directly to that source. And well, this is a source which is applicable when the defendant is domiciled in the European Union. But sometimes, even when the defendant is not domiciled in the European Union, it is going to be applicable when the dispute involves exclusive jurisdiction issues of those covered by Article 24, or when the parties have agreed to the jurisdiction of the courts of a European member state, either expressly or implicitly, Articles 25 and 26. That's the most important source in the area of international jurisdiction when we talk about commercial matters, commercial disputes. But also, I have mentioned the Lugano Convention 2, the version from 2007, because, well, we could say, or we could discuss, but this would be a theoretical discussion, whether we could consider this a source which belongs to European Union law or not. But the good question about this is that this convention is also in force in all European Union member states, including Denmark, and also in Iceland, Norway, and Switzerland, which, you know, are states from the European Free Trade Association. All of those states, with the exception of Liechtenstein, are parties to this convention. And this convention, as you probably recall, is basically exactly the same as Regulation Brussels 1. Okay, not Regulation Brussels 1 bis, but Regulation Brussels 1. We are in the process now in the European Union of amending Lugano Convention 2 to make it the parallel convention to Regulation Brussels 1 bis. But this is something that it's being discussed nowadays. But in the area of jurisdiction, to tell you the truth, the Lugano Convention 2 is basically very, very similar to Regulation Brussels 1 bis, because as you know, the transition from Regulation Brussels 1 to Regulation Brussels 1 bis was not that strong, that important, or that crucial in jurisdiction matters. Basically, we share the same rules, with the little thing here and the little thing there. So, well, the Lugano Convention, it's quite interesting for us, and it's quite interesting from the potential perspective of future perspective of the UK, because it's something that applies in here with us in the European member states, and those three other states which are not European Union member states. In the area of applicable law, we have two very important regulations. The most important in commercial matters is the first one that you see there, which is Regulation Rome 1. This is the one determining the law applicable to contractual obligations, but also sometimes in commercial matters or in commercial situations or transactions, we would need to take into account that we also have Regulation Rome 2, where you will know how to determine the law applicable to a non-contractual obligation. Okay, so those two regulations for us are very important, because basically they deal with the law applicable to any kind of obligations which are either contractual or not contractual, and specifically torts. And finally, in the area of recognition and enforcement of foreign decisions, we do not have a specific instruments within the European Union, because those rules dealing with recognition and enforcement of foreign decisions are in Regulation Brussels 1 bis or in the Lugano Convention, which are double topic regulations or conventions. They govern international jurisdiction and recognition and enforcement of foreign decisions. So for us, if we are European Union lawyers and we have to work out issues of international jurisdiction for the courts of the European Union member states, or how we determine the law applicable to a contract or a non-contractual situation from the perspective of the European Union, well, these are basically the most important sources in the area of international commercial law. Well, let's take a look at what happens to international jurisdiction from the UK perspective, because they are no longer members of the European Union, so therefore they don't share those legal instruments with us, right? So, well, in the first place, what I'm just simply saying there is, well, the UK is back to the past. I mean, back to the past in the sense that for almost 50 years, they have been using rules created by the European Union, rules which basically, I wouldn't say resemble that much common law principles. In the European Union, the civil law approach is still predominant, but for a while they have been happy with this, at least happy in the sense that they accepted to be bound by those regulations and those sources. But now they have returned to the old times, and the old times, by that I mean before they joined the European Union. So the private international law sources nowadays enforced in the European Union are basically in the area of international jurisdiction, obviously domestic law, domestic international jurisdiction rules, either statutory or case law, and sometimes international conventions. You shouldn't forget that in the area of international commercial transactions, there are a number of international conventions which govern jurisdiction and other issues. And just let me give you an example: the CMR, which is the Convention on the International Contracts for the Carriage of Goods by Road. Well, this convention is in force in the UK, is in force in all European Union member states and many other countries which are not European Union member states. And there is an article in that convention, which is Article 31.1, which deals with jurisdiction. So, well, we have that. We will talk later about more common ground with the UK, but still today, even if the UK left the European Union, we share some of those international conventions. But again, out of a situation covered by those international conventions, now in the UK, in order to determine the international jurisdiction of English courts to hear an international commercial dispute, that's basically in the hands of their domestic rules, which obviously it's a huge change, not necessarily for them, but also for us, because we need to adapt to this present situation. What you will see there in the second place is just a comment on a discussion that had been exchange basically in the academia about whether the Brussels Convention from 1968 was still in force and applicable in the UK. As you know, the Regulation Brussels 1 bis was preceded by Regulation Brussels 1, and Regulation Brussels 1 was originated in the Brussels Convention from 1968, which is, again, it's the regulation, but a convention in 1968. That we had a convention because at that time the European Union did not have the power to legislate on private international law, so we had to do it through this parallel system of using international conventions. And the UK is still a contracting country of the Brussels Convention. So someone has suggested, well, but the UK is no longer a member of the European Union, that the European Union rules cannot apply in the UK, but, well, the Brussels Convention is an international convention, so, well, we could think about its potential application. Well, basically, the answer to this question has been answered in the negative for many reasons that I don't have time to share with you here, right? But in addition to that, with the 1968 convention, well, it's an old convention. It's very similar in basic terms to the rules that we have now in Regulation Brussels 1 bis, but it comes from a different time, and I don't think this would be a good idea for the UK to claim that, well, if we want to be doing something in parallel and similar to what they do in the European Union, let's do it through Brussels Convention. I don't think that's the way to proceed. A better attempt, and I would say that this would be more reasonable, is that the UK becomes a contracting state of the Lugano Convention, like, again, Iceland, Norway, and Switzerland. And in fact, the UK applied to become a party of this convention on April the 8th, 2020. However, the European Union has opposed to this. And if you want to read more about the reasons why the European Union decided, no, we are not going to allow you to join this parallel club, which is the Lugano Convention, you click here in this document. I'm going to show that to you very briefly. And it's from, this 2021. It's a communication from the Commission to the European Union Parliament and the Council, empty, assessment on the application of the United Kingdom of Great Britain and Northern Ireland to accede to the Lugano Convention. And if you go all the way back here in the conclusion, you will find out exactly why the European Union has denied at all that this is a possibility for the UK to join us through this parallel proceeding, all right? You may agree or not with those reasons in the conclusion, but this is what it is. So I don't think that unless there is a political change about that, the UK is going to be basically allowed to be part of the Lugano Convention, which, again, it would be somehow reasonable because this is what happens in Switzerland, this is what happens in Norway, this is what happens in Iceland, and these are countries with a very close connection or ties with the European Union, right? So far, if we have to give advice to local clients here on potential claims to be filed here or there in the UK in relation to UK-based parties. This is what we have now, the European Union perspective with our rules and the UK perspective with their rules. So we only have in common so far those rules dealing with jurisdiction in specific or special international conventions. In addition to this, well, let me tell you now exactly what would be the perspective of European Union member state courts involving UK-based parties. So it's a situation where, again, we are not going to deal what happens if you file a claim in English courts. We're going to take a look at this from the perspective of European Union member state courts, right? When one of the parties is UK-based. First, as you know, I told you, and that's in the second slide, regulation Brussels 1 bis applies only when defendant is domiciled in the European Union. This is the general rule, and there are exceptions that we will review now. But if this is so, obviously, you cannot bring a claim against a UK domiciled party in the European Union member state courts under regulation Brussels 1 bis, unless you are in one of those exceptions. Well, the first exception is exclusive jurisdiction, Article 24. There are a number of situations in Article 24 where the courts of European Union member states have exclusive jurisdiction to hear a dispute, even if defendant is not domiciled in a European Union member state. In the area of commercial transactions, to tell you the truth, Article 24 is not that helpful because we only have the first section, 24.1, dealing with tenancies of immovable properties. So, well, this is the only kind of contract transaction which would be governed by this exclusive jurisdiction rule. And secondly, you may file a claim in courts of European member states in international commercial transactions, even if defendant is not domiciled in the European Union, when there is a choice of European Union member state courts, either expressly or implicitly, Articles 25 or 26. So, well, this could be one of the situations where you could bring UK-based defendants to a court in a member state of the European Union, as long as in that transaction they have chosen the courts of a European Union member state. So that's the limited approach to the jurisdiction, international jurisdiction of European Union member state courts when we have a UK-based parties. So is this the end of the analysis? Well, no, because if we have a situation where regulation Brussels 1 bis is not applicable, then in each member state of the European Union, we still retain our domestic international jurisdiction rules. So there might be a situation where in UK-based parties, which cannot be tried in European Union member state courts under regulation Brussels 1 bis, is going to be allowed to be tried here on the basis of our domestic international jurisdiction rules. Nowadays, our domestic international jurisdiction rules are somehow modeled or copied from regulation Brussels 1 bis, but I'm not sure that this is happening in all 27 member states of the European Union. But still, there is some ground for the jurisdiction of European Union member state courts in the courts of that member state when the defendant is domiciled in outside of the European Union, or when regulation Brussels 1 bis is not applicable. Okay, and by the way, this is the reasoning that you have also to apply when you discuss about the international jurisdiction on the basis of the Lugano Convention from 2007, because the rules are not 100% the same, because there are some little differences in relation to choice of courts, etc., etc. But basically, this is the same grounds, right? Do we have any real common ground so far with the UK in relation to international commercial litigation? Well, Yes, and this is a positive approach because we shared one international convention, which is very much limited in its material scope. But well, if we can share everything, at least we could do something about this, right? And this is the convention that you probably know, the Convention on Choice of Court Agreements. It was a convention from 2005, which entered into force, internationally speaking, in 2015, which basically applies to situations of international jurisdiction, but also, don't forget that, because that's in the final part of the convention, also applies to issues of recognition and enforcement of foreign decisions. And well, when you take a look at the status table of this convention, and let me share that information with you here, you will find out, this is the list, right? You will find out that all European Union member states, again, including Denmark, are parties to this convention because it was signed by the European Union. You see here, European Union. I'm highlighting this because, as you know, the European Union now has basically not 100% exclusive, but close exclusive powers to enter into international conventions dealing with private international law. So here, the majority of the member states of Europe, I mean, all member states of the European Union are contracting states. Someone says that the share screen is not showing when you click through. Okay, maybe because let me try to see how we do this. So I'm going to stop sharing. I'm going to share now this. Let me, I think you should see it now, right? So, okay, so this is the list of the contracting states of the convention. Well, if you take a look at the dates, the European Union signed this and entered into force in 2015, including the UK, right? Because you see the UK is here. So the UK was a party to this convention because it was a member of the European Union. And now that the UK is not a member of the European Union, what has happened? Well, the UK has, as you see here, joined again. Okay, this is a funny situation. They were members of the convention. They were contracting states of the convention as member states of the European Union. They are no longer, and now what do? Well, they decided, okay, we are not sure if we are a contracting state since 2015 or we are going to do it on our own. So, well, I think this is important for us when we take a look at the situation from the European Union, and we could say, oh, well, we share something with the UK, this convention. And well, we share that with the UK. And by the way, if you're curious, also contracting states of this convention up to date are Montenegro, okay, Singapore, and there's one more here that I'm missing, which is, let me see. No, Mexico is here, okay? So European member states plus the UK plus Mexico, Montenegro, and Singapore, and all of the rest of the countries which might join in the future. So, well, when we discuss about having something in common, well, we have this convention. It is true, and let me go back to the presentation. So where is the presentation here? Just let me go back here. When we go back to our common ground, we could say, well, this is good. However, this is not a fully international jurisdiction source because it only deals with those situations of international jurisdiction when there is a choice of courts. And as you see here, this convention applies only to exclusive choice of court agreements in situations or matters not excluded by Article 2, when the choice has been concluded after the date of entry into force of the convention in the country of the chosen courts. Well, I would say that, as you probably know, that sometimes in certain areas of business and certain sectors, it's quite common to choose the law of England and Wales as the law governing the contract. At least this is something that I know quite well from my shipping law perspective. Okay, the contract has no contact at all with the countries involved in the transaction, but they choose English law. Well, if the choice of English law is going to be still prevalent in certain choice of jurisdiction, courts, is going to be prevalent in certain business sectors, I would say that this convention is great, because at least we know that a choice of the courts of England is going to be valid and acceptable in other countries which are parties to the Hague Convention, including the European Union, and well, we will not share other rules dealing with jurisdiction, but it's still we share that. So, well, we still have this indirect way of building up some common ground in this area of international jurisdiction. Well, let me show you next in the area of applicable law. This, for whatever reason, this has been a completely different area of private international law, and in this specific situation of the relationship between the UK and the European Union after Brexit. And I'm telling you that the situation in the area of applicable law is still the same as the one we had before Brexit. And why is that? Because simply, well, UK has approved this so-called the law applicable to contractual obligations and non-contractual obligations amendment, etc., regulations 2019. In other words, regulations Rome 1 and Rome 2 are not applicable in the UK because they cannot be applied there, because the European Union has said, bye-bye UK, you are no longer a member state of the European Union, but the UK has said, okay, I'm going to use those regulations. So I'm going to have the same rules in the UK as you have in the European Union, with certain changes and modifications. So I think this is also a very important common ground for different reasons and through a different procedure that we have in this area of the law applicable to contractual and non-contractual obligations, because we could still today advise the client here on what would be the perspective of determining the law applicable to a contract or to a tort in the UK, because even if they don't have the regulations as such, they have almost exactly the same type of rules. And well, I think this is important. We are going to have problems in the area of international jurisdiction, but at least we share those rules on the area of applicable law. In relation with these regulations, and specifically with the issue of the law applicable to contractual obligations, I tried here to highlight three issues which I think are important still today in relation of the European Union and the UK approach to regulation Rome 1. In the first place, you see here that I'm telling you that in the past, when the UK was a member state of the European Union, well, the UK courts were very flexible in the application of regulation Rome 1, and specifically in their approach to the acceptance of implicit choice of law clauses and the possibility of escaping from the law otherwise applicable to the contract under regulation. This was something very curious, because in the rest of the member states of the European Union, we were not that much in favor of accepting implicit choices of law as they are allowed in Article 3.1 of Regulation Rome 1. And this idea of escaping from the law applicable to the contract, when we already know the law applicable to the contract, was not also very familiar to courts in other European member states. But the UK courts offer a different perspective to this. So I think this is an issue that we need to keep in mind that, if they are going to have now rules very similar to Regulation Rome 1, where you will find implicit choice of law and escape devices, we need to understand that the UK, the English position to those mechanisms is still in force. What you will see here, what I say written, is basically, if you click here, I'm not going to do it now, but if you click here, you will be taken to a very good paper written in English by a Spanish law professor analyzing UK case law in relation to Articles 3.1 and Article 4.3 of Regulation Rome 1. So this, I would say, this is still good law, at least in the UK, in relation to those two mechanisms. The other two issues that you will find here are this changed quite much now, that even if the UK is out, but with similar rules, but we need to be careful with the approach to the situations of Article 3.4 Regulation Rome 1 and Article 9. In the first place, Article 3.4, it's one dealing with the so-called intra-European Union cases. So this is a situation where all the elements to the contract are connected with the European Union. So you take a look at the contract and everything that you see there is connected with the European Union, except the fact that the choice of law made in that contract is the law of a non-European Union member state, which in my seminar today would be the choice of the law of England and Wales. So shall we respect the choice of the law of England and Wales, even though all the elements of the contract are connected fully with the European Union? Well, the answer is yes, but the choice shall not prejudice the application of European Union provisions where appropriate is implemented in the member state of the forum, which cannot be derogated from by agreement. So in other words, if we have that situation and we choose, or the parties choose English law is going to be applicable as long as it does not contravene or contradict European Union mandatory rules. Obviously, when the UK was a member state of the European Union, they share with us the same rule. But now, when we take a look at this from our perspective, we need to consider that, yes, English law is one of the national legal systems which is going to be affected by the new approach to Article 3.4. And finally, Article 9 of Regulation Rome 1 is an article dealing with the very strange so-called overriding mandatory provisions. Those are very exceptional provisions which will be applicable irrespective of the law otherwise applicable to the contract under the regulation. And the problem here is, well, imagine, I'm going to give you an example, and quite the example would be that the one that you have here in the Ingmar case. Okay, that's a very old case, but it's still very important because it defined how to apply Article 9 of Regulation Rome 1. But imagine a situation where you have an agency, commercial agency agreement between a principal in the UK and an agent in a European Union member state like Spain, right? And well, the choice on the law applicable is the law of England. Okay, so well, we could say, well, it's an international contract. There is an agreement on the law applicable. It's the law of England. That's valid under Article 3.1 of Regulation Rome 1. Well, now that the UK is out of the European Union, the UK should be viewed or treated from the perspective of Article 9, because the law of England will be applicable as long as it does not contradict the overriding mandatory provisions that you find in the law of the forum or in the law of a third country connected with the contract. And in this particular case, and let me share that with you. So I'm going to go share 1 minute, share here. If you see this is the judgment in the Ingmar case, and we go to the answer to the conclusion of the court, here it says, you need to understand that this is a specific case in the area of the commercial agents, the application of the directive of commercial agents. But look at this, it says, Articles 17 and 18 of Council Directive, etc., which guarantees certain rights to commercial agents after termination of contracts, must be applied where the commercial agent carried on his activity in a member state, although the principle is established in a non-member country, and the clause of the contract stipulates that the contract is to be governed by the law of that country. Obviously, when this case was decided, the UK was party to the European Union, so well, we couldn't have any thoughts about that. But now that the UK is out, and again, we sometimes choose the law applicable to the commercial agency agreement, and it's going to be the law of England. Well, it's not only the law of England, because in addition to the law of England, we will have to apply the overriding mandatory provisions that you find in the law of the foreign or in the law of a third state connecting with the country. So, well, the message here is great. We're going to have a situation where the rules and applicable law are basically the same here and there, but it's still today the approach to some specific rules in Regulation Rule 1 are not going to be the same. All right. Well, let me conclude. I think I have a couple of more slides here. When we talk about recognition and enforcement of foreign judgments, what is the situation now? Well, if we have a European Union member state court judgment and we need to ask for the recognition and enforcement of that foreign judgment in the UK domestic rules will apply after Brexit. Okay, so this is clear. You need to enforce a Spanish decision, court decision in England. You need to review English law on the matter. What happens the other way around if we have a UK court judgment and we need to enforce that in European Union member states? Well, here we have two situations. If the UK judgment was issued in proceedings initiated before the 1st of January 2021, Regulation Brussels 1bis still applies. But if the judgment was issued in proceedings initiated on or after January the 1st, 2021, then Regulation Brussels 1bis does not apply. And we will have to take a decision on whether to enforce that UK court decision in Spain or in Italy or in Germany on the basis of our domestic rules dealing with recognition and enforcement of foreign judgments. Okay. However, don't forget what I told you before. If we are talking about the recognition and enforcement of a foreign judgment issued by a court on the basis of a choice of courts made under the Hague Convention, that decision may be enforced freely in all contracting states of the Hague Conference, which is basically, European Union with Denmark, UK, etc., etc. Well, and finally, do we have any future common ground with the UK? I'm pointing out here to this convention, which is a convention that we need to take a closer look at because it's going to be entering into force in September the 1st, 2023. This is a very similar convention to the Choice of Courts Convention. It's produced by the Hague Conference on Private International Law. So it's a convention open to signature by all countries around the world. The European Union, all of them, all the member states are parties to this convention. Also Ukraine, and the UK is not yet a contracting party. Okay, so this is what we would need to review in the future. What is the UK going to do with this convention? Because they could do something similarly to what they have done in the area of choice of courts join this convention, and this way we would have a free movement of decisions in relation to their enforcement and recognition in all European member states plus Denmark, Ukraine, the UK, if so, and the rest of the countries which want to join the club. And finally, in relation to service of legal documents on UK parties, obviously, the European Union law is no longer applicable in the UK, so the service will have to be performed according to international instruments or other available mechanisms available here or there. And this is the final shot here. I'm simply mentioning European Union private international law instruments, which were enforced in the UK, and they are no longer enforced in the UK. And they deal with quite interesting areas of law which are connected with international transactions. So these are the shortcomings of leaving one of the members of the European Union, that those regulations which were some of them more or less practical in terms of legal advice to our clients, but they are enforced here for us, but they are no longer enforced in the UK. So if we have any of those issues on the table, we will need to figure out exactly what is the parallel rule or source of regulation in the UK, sorry, dealing with this. So I think this is the end of the presentation, and well, I'm very happy to hear from you if you have any questions or any comments or whatever you want to share with me. Let me take a look at I talk for 5 more minutes than I expected. Okay, so if you want to say something or share something with me, I'm happy. We could have 5-10 minutes, so it's up to you. And if not, we go back to what we had to do, right? So let me check. There's something here in the chat.
Yes, question.
Andrew Dana says, what would the European Union handle a situation where the UK and the European Union members are parties to the same treaty, but they interpret it differently? Well, that's a typical problem of the interpretation of treaties, right? That it all depends on national interpretation, unfortunately, but depending on the treaty. I'm thinking, for instance, in the CISG, which is enforced nowadays in 95 countries. By the way, I've heard that Hong Kong is going to join the CISG. I don't know how Hong Kong could join the CISG when China is already a member state. But again, it's a huge international convention, and how do we provide a uniform interpretation to the rules in the CISG, which, by the way, all European member states are parties to the CISG, with the exception of Ireland. By the way, Ireland is not a contracting state of the CISG. Well, we don't have any common and unique and exceptional way to have a uniform interpretation. We have the share of the information of decisions from other countries. We have beautiful databases with where we can read different cases from different countries and try to find out there's some common ground. But again, this is a problem, Andrew, of course. Within the European Union, we don't have any problem because the Court of Justice of the European Union is the final and sole interpreter. But when the UK is living now, well, we have to go to the old mechanisms of interpretation of international conventions. Edith talks about, what about European Union consumers and a UK party breaching consumer law? Well, I'm not going to answer because that's not international commercial law, and you know more than me, Edith, about that, right? Well, you know that consumers are somehow protected in the area of international jurisdiction and applicable law because there are specific articles in Regulation Brussels 1 bis which deal with how to treat consumers in relation to choice of courts, when there's no choice of courts, whether the consumer is active or passive. And also in relation to the law applicable to consumer contracts, we have Article 6 in Regulation Rome 1. I would say that, well, as we have Regulation Rome 1, Article 6, and the UK will have or has already a similar article to Article 6 of Regulation Rome 1, there will be no, I don't think there will be any differences between UK and member states. In the area of international jurisdiction, I'm not sure. That would be something on English law to determine the jurisdiction of English courts. Let me also remind you that the Hague Convention on Choice of Courts is not applicable to consumer transactions. So, well, here, specifically in that area of international jurisdiction, probably we will have different, or very different approaches, okay? Well, anyone else, any questions? No questions, it's 3:54 here, so, well, let me thank you very much for joining me. It was a pleasure to be part of this webinar series, which is I was going to say it's a project. No, it's not a project. It's a reality that we have now in the EALG. This webinar will be posted in the EALG website, and also I will make it possible that the presentation, the PowerPoint presentation, is also reachable there, because it's a interactive presentation. So probably some of you would like to have a copy of the presentation, just to read back and click on the links and be taken to somewhere else. So, well, let me see, there's 2 additional messages. Those are thank you. Well, thank you again. So if you don't have anything else to comment here, I will leave you with what you have to do, and just simply let me express my gratitude, and I would like to see you in present, at least those of you members of the group, in our next meeting. So bye-bye.
Thank you.
No, thank you.
Thank you very much.
Thank you. Andrew, I think we need to have a conversation, right? Are you there?
Thank you very much, Carlos. Very interesting.